Well, we have another Chilli order today, this time on his motion for a protective order in the Ohio case. Let's get going. So it's a memorandum opinion and order. Pursuant to local practice, all non-dispositive motions in this pro se civil rights case have been referred to the undersigned. In addition to two dispositive motions filed by defendants, plaintiff has filed a non-dispositive motion that seeks a protective order from discovery requests propounded by defendants. For the reasons below, plaintiff's motion is denied. Right, I don't know if we need to go through the back. Maybe I will. Background. On April 13, 2022, plaintiff Jose Maria de Castro, a resident of California, paid the filing fee and initiated the civil rights action against multiple defendants, including the City of Arlington Chief of Police and 4 individuals and a Jane Doe employee. Plaintiff also named the City of Arlington itself and Lawrence County as defendants. 2 groups of defendants, hereafter the county defendants and city defendants, filed separate motions to dismiss and for judgment on the pleading. When plaintiff failed to timely respond to either of those motions, the court filed orders to show cause with deadlines of July 22 and August 11, 2022, respectively. Plaintiff did not respond to the first show cause order, but responded to the second on the deadline of August 11, 2022. In his response, he states that before July 27, he received nothing from either this court or the defendants, even though his postal address has remained the same throughout this case. The court accepted the response in satisfaction of both show cause orders and permitted plaintiff another 30 days until September 15, 2022 to either respond to the pending motions or file an amended complaint. On that deadline, plaintiff filed an amended complaint that appears to narrow the list of defendants by eliminating claims against all 3 county defendants, including Lawrence County, Major Chapman, and John Doe, as well as one of the city defendants, the City of Arlington. In his amended complaint, plaintiff alleges that he is a videographer, vlogger, and civil rights activist who has been video recording, publishing his recordings, edited and unedited, on media forums such as YouTube, Facebook, Instagram, and the like since approximately 2020. Plaintiff generally alleges that defendants violated his First, 4th, and 14th Amendment rights under 42 U.S.C. 1983, beginning with an incident on Tuesday, March 29, 2022, when plaintiff was arrested by 4 officers at the Arlington City Hall. Plaintiff alleges that the arrest was unlawful and that defendants improperly demanded his social security number and unlawfully seized and damaged his personal property. Plaintiff states that the criminal case related to the unlawful arrest is still ongoing. His amended complaint seeks punitive and exemplary damages for $1 million against all named defendants, jointly and severally. On September 22 and 29, 2022, defendants filed new motions to dismiss and for judgment on the pleadings in response to the amended complaint. When plaintiff again failed to timely respond, the court again entered 2 orders to show cause, listing deadlines of November 17 and November 30, 2022. After plaintiff failed to respond to either order, on 6 December 2022, the court terminated this case and entered judgments for all defendants. The next day, on December 7, 2022, plaintiff moved for leave of court to further extend his time to respond to the motion for judgment on the pleadings, citing excusable neglect and asserting that he had not received 2 of the 3 orders to show cause, which resulted in delayed responses, and incorrectly claiming that he had attempted to respond on Monday, December the 5th, which is within the deadline for responding. Both city and county defendants strongly opposed plaintiff's motion to extend time and implicit request to reopen the case, noting the large number of documents that they have served plaintiff with at the address listed of record and simultaneously served via email by the city. Counsel for the city defendants also filed an affidavit confirming that no return mail has ever been received. Both city and county defendants cited to well-established case law holding that a litigant's pro se status does not excuse his compliance with deadlines, and noted that this case has been much delayed by plaintiff's conduct, suggestive of gamesmanship. But giving plaintiff the benefit of the doubt, the court vacated its judgment and granted him an extension of time to respond to defendant's pending deposited motions and notation order of 13 January 2023. Plaintiff then waited until the extended deadline of January 13, 2023 to file his joint response in opposition to those motions. Defendant's deposited motions remain pending before the presiding district judge. However, on May 15, 2023, plaintiff filed a non-dispositive motion for a protective order that has been referred to the magistrate judge. On May 22, 2023 and on May 25, 2023, the city and county defendants filed responses in opposition to plaintiff's motion, to which plaintiff has filed separate replies. For the reasons below, plaintiff's motion is denied. Analysis of plaintiff's motion for protective order. Federal Rule 26C governs protective orders and grants discretion to the court to fashion discovery in a manner to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Federal Rule of Civil Procedure 26C. Plaintiff seeks a protective order to stop defendants from participating in premature discovery that violates the Federal Rules of Civil Procedure in order to harass and or unnecessarily burden plaintiff to keep personal information confidential and any other relief that this court deems proper. Plaintiff states that on March 8, 2023, county defendants Chapman, Lawrence County and Jane Doe initially emailed written discovery requests. Plaintiff responded by objecting mainly on procedural grounds and immediately threatening sanctions. Did you mean to send interrogatories, especially these ones? Sending interrogatories without leave of the court before the 26th F meeting is improper, and these questions are mostly requesting things that will be in my initial disclosures or for things wholly inappropriate, especially given my claims. Should I disregard these, or is there any reason why I shouldn't file a motion for sanctions? I'm considering doing exactly that. Were you unaware that you're out of bounds? The county defendants promptly responded, acknowledging the procedural error and instructing plaintiff to disregard the requests. I was mistaken in my belief that a Rule 26F report was completed in this case. After reviewing the docket, I realised that it has not been completed. Please disregard the first set of written discovery that I've sent. I will send it to you once more when the Rule 26F report is filed. On April 11, 2023, plaintiff received a similar set of written requests from city defendants Pam Wagner, Brad Spragic, Chance Blankenship, Evan McKnight, Robert Fouch, and or the City of Ironton by mail. Plaintiff states that he found the city defendants' request to be less substantially objectionable, but still objected because they were served before a Rule 26F meeting. Rather than communicating that objection, however, he decided not to respond at all because it wasn't worth typing up a reply letter. Defence counsel politely contacted plaintiff more than a month later to ask about the lack of responses. Can you please advise on the status of your discovery responses and when we can expect your responses? As with the county defendants, plaintiff immediately replied with a threat of sanctions. The tone of plaintiff's email speaks for itself. My God, the ineptitude is staggering. You won the dunce cap of the day award. They're not getting away with it, especially with lawyers like you. You are going to make sure that they won't get away with wrongfully arresting me. Did you mean to send me the interrogatories, especially these ones? Sending interrogatories without leave of the court before the 26F conference is improper, and these questions are mostly requesting things that will be in my initial disclosures or for things wholly inappropriate. Especially given my claims, should I disregard these, or is there any reason why I shouldn't file a motion for sanctions? I think I'm going to file a motion for sanctions. I won't rest until my good name is cleared. Remaining professional on May 9, 2023, Defence Counsel asked plaintiff for times that would work and a valid phone number to meet and confer regarding a Rule 26F discovery plan. We are happy to schedule a Rule 26F conference. Please provide us times in the next 2 weeks that work for you and a phone number to reach you, and we can confer regarding a discovery plan. Attached is Judge Barrett's discovery plan form that we can discuss. If you prefer to exchange suggestions on the discovery plan via email, let us know. Thank you. Plaintiff again chose not to respond, instead moving for a protective order 6 days later. In his motion, he argues that courts have the authority to stay discovery while depositive motions are pending. Based on that authority, plaintiff asserts that there will be no Rule 26F meeting until the depositive motions are decided. Yet plaintiff has never sought a stay in this case, which has now been pending for more than a year without a preliminary Rule 26F meeting. Plaintiff's motion is denied first because it is moot. Once alerted to plaintiff's procedural objection to participate in discovery prior to a Rule 26F conference, counsel for both city and county defendants made clear that they agreed that no responses to the request would be required before the conference. Counsel for the county defendants explicitly told plaintiff to disregard the first set of written discovery that was sent because it will be sent again when the Rule 26F report is filed. Counsel for city defendants responded to plaintiff's pejorative email by requesting plaintiff's telephone number and dates and times for a Rule 26F conference so that discovery proceed. A request that plaintiff flatly ignored. Plaintiff's reprehensible conduct provides the second basis for denying his motion. I'm going to have to stop there because the judge has just said plaintiff's reprehensible conduct. Under the Federal Rules of Civil Procedure, a motion for a protective order must include a certification that the movement has in good faith conferred or attempted to confer with other affected parties in an effort to resolve the dispute without court action. Plaintiff's motion contains a role statement that he attempted in good faith to confer with defendants' counsel to resolve this dispute, but has been unsuccessful. Based on the record, the statement is patently false. Again, I'm going to have to stop there because the judge is now calling Chilli a liar. Along with the referenced Federal Rule of Civil Procedure, the Southern District of Ohio has published Local Rules SD Ohio Civil Rules 37.1 entitled Consultation Among Counsel, Informal Discovery Dispute Conference provides. Objections, motions, applications and requests relating to discovery should not be filed in this court under any provision in Federal Rule Civil Procedure 26 or 37 unless the parties have first exhausted among themselves all extrajudicial means for resolving their differences. After extrajudicial means for the resolution of differences about discovery have been exhausted, in lieu of immediately filing a motion under Federal Rule of Civil Procedure 26 or 37, any party may first seek an informal telephone conference with the judge assigned to supervise discovery in the case. Last but not least, U.S. District Court Judge Michael R. Barrett presides over this civil action with non-depositive matters referred to the undersigned magistrate judge. Section D of Judge Barrett's standing order regarding discovery motions states, "This court does not permit discovery motions, i.e. motions to compel or motions for protective order regarding discovery disputes, unless and until counsel use the following procedure. Counsel must first attempt to resolve disputes by extrajudicial means required by SD Ohio Civil Rule 37.1. This court defines extrajudicial means as requiring counsel to try to resolve the matter both in writing and telephonically. If counsel are unable to resolve the dispute between themselves, then they must contact the courtroom deputy Krista Zeller, and a telephone conference with all counsel and the court will be scheduled as soon as possible. The undersigned standing order similarly states that this court does not allow motions relating to discovery until an informal discovery conference is held. An informal discovery conference with the court may be scheduled only after the parties have exhausted all extrajudicial means of resolving their dispute. A reference there. The undersigned's standing order applies to cases referred under 28 U.S.C. 636 (b), as well as to cases in which the parties have consented to final judgment by a magistrate judge under 28 U.S.C. Section 636 (c). When a presiding district judge's procedures differ in a case referred under 636b, the parties must comply with the district judge's procedures. Again, a reference. Plaintiff's conduct here violates Federal Rule of Civil Procedure 26C, SD Ohio Rule 37.1, and the standing orders of both the presiding district judge and the presiding magistrate's judge. Sorry, I'm going to repeat that one. Plaintiff's conduct here violates Federal Rule of Civil Procedure 26C, SD Ohio Rule 37.1, and the standing orders of both the presiding district judge and the presiding magistrate judge. Oh dear. Plaintiff's initial response to the county's discovery request focused less on dispute resolution than on his threat to move for sanctions. After the county's counsel responsibly acknowledged the procedural error, directed plaintiff to disregard the first set of written discovery requests until after the Rule 26F conference, no dispute remained. It also remains unclear whether plaintiff's amended complaint continues to seek liability against the county defendants. In any event, plaintiff made no further attempt to communicate with opposing counsel for county defendants before filing his motion. Plaintiff's failure to communicate with counsel for the city defendants is even more egregious. After receiving discovery requests from that group of defendants, plaintiff admits he did not bother to respond at all. When counsel eventually asked about what they perceived to be overdue responses, plaintiff attacked with pejorative and extremely uncivil email in which he again threatened sanctions. He ignored counsel's reasonable follow-up request to provide a telephone number or dates and times for a Rule 26F meeting so that this case might proceed. Rather than notifying counsel of any remaining dispute, brackets, again there is none, close brackets, he moved for a protective order. And despite seeking a protective order on grounds that the discovery requests are duplicative of information to be provided in his initial disclosures, plaintiff refuses to participate in Rule 26F conference or to provide those initial disclosures. In his reply memoranda, plaintiff maintains that he was unaware of the court's standing orders and offers a cursory apology. He then blames defendants for their alleged failures to request a meeting with the court's courtroom deputy in compliance with the standing orders. He suggests that this court should overrule defendants' objections as moot based on the alleged non-compliance. But as the party requesting a protective order, it was plaintiff who had the obligation to contact the court before filing any discovery-related motion. And to be clear, plaintiff had no right whatsoever to contact this court prior to fully exhausting all extrajudicial efforts to resolve his dispute in good faith, meaning that he must communicate more than once in writing with opposing counsel about the details of any dispute and pick up the telephone if he cannot resolve the issue through written communications. Based on plaintiff's course of conduct to date, He will be ordered to immediately contact Defence Counsel for both city and county defendants in writing to provide dates and times for a Rule 26F telephonic conference. If all parties agree to delay the exchange of initial disclosures under Rule 26(a), or if they wish to delay substantive discovery until the presiding district judge rules on the pending deposited motions, they may express their agreement in their jointly filed report. That said, the parties are not excused from their obligation to meet and confer and to file a Rule 26(f) report. As a third basis for denying plaintiff's motion, both city and county defendants argue that the disputed discovery requests are well within the scope of permissible discovery in this case and on their face do not support a protective order. See Rule 26C. Too much of the court's time has been spent in reviewing the record and plaintiff's improperly filed motion. Because no written discovery requests are pending and plaintiff's motion is denied on procedural grounds, the undersigned declines to reach the merits of the motion for protective order. Conclusion and order. Accordingly, it is ordered. 1. Plaintiff's motion for a protective order is denied. 2. Plaintiff is forewarned that pro se litigants are not excused from complying with all applicable civil rules of procedure and all orders of this court, including standing orders. Should plaintiff file an improper discovery motion or fail to fully comply with the same civil rules and procedures in the future, he may be subject to sanctions. Based on the age of this case, the parties are directed to file their joint Rule 26(f) report not later than 14 days from the date of this order. Within 3 days of the date of this order, plaintiff must contact all defence counsel in writing via email and list not fewer than 4 times on weekdays during which plaintiff is available to meet and confer telephonically for a Rule 26F conference. The reference dates must allow sufficient time for compliance with paragraph 3 of this order, and any specified times must fall between the hours of 9 a.m. and 5 p.m. Eastern Standard Time. And it's signed by Stephanie K. Bowman. I bet we'll get another sexist rant from Chilli. Sorry, I thought best to read it all because it is the Arnton case and probably need a refresher. Thanks for watching.